everyone, it's Reeps US here, and today I'm bringing you a holiday special courtesy of the SEC. As we can see, I've shown the plaintiff here, and the best picture I could find is this hot coal, and our defendant is Ripple, who is here depicted as Santa Claus. And I think that's the best way to sum it up of what's going on this holiday season with this gift from the SEC. And just a quick disclaimer before I get into this, I'm obviously not a legal or financial analyst. I'm just a normal guy who has bought some XRP and trying to make some sense out of what's going on and what the merits of the claim are and what the merits of the defense are going to be. And really, I think what it comes down to, people want to know, do we think the SEC is going to win? And before I talk more about the SEC, this is quite interesting to me what's happened with the XRP market. Now, the SEC claims to me are not really groundbreaking, and that's because, as many of you know, there's been an ongoing lawsuit from so-called retail investors for about 2 years now, who initially made the same claims. They filed a ton of amendments. I might do another video on that. But that lawsuit didn't have the same spook effect here. So I wonder if it's a knee-jerk reaction. Is it a knee-jerk reaction, or is it justified with what we're seeing in the XRP market? Well, the SEC obviously thinks it's justified. They have a press release going here from December 22nd when they served the claim on Ripple. And so they're just letting the world know that they charged 2 Ripple execs with conducting what they claim is a $1.3 billion unregistered securities offering. So they're saying essentially, I guess, since the inception of the XRP and when they started distributing and selling them, that these are securities. Obviously, Ripple thinks otherwise, and that the XRP is a cryptocurrency. And I'm of the same mind, to be honest. Now, I think the key thing here to understand this, and it's going to be hard in court as well, how do you differentiate between what is Ripple, what is XRP, when a lot of people just, they assume XRP is Ripple. Yes, they did create it, but XRP on its own, I think this might be interesting for the, final determination here. But if Ripple were to die today, XRP would continue to function. And I think that's what people need to understand. As much as the SEC says that they have promoted Ripple as the XRP cryptocurrency, and that all appreciation and all this stuff that's going on of it, market value was simply due to their promotion. And so it's going to come down to the Howey Test, which I'll also talk later on about. Okay, but first, what is Ripple? Well, they call themselves RippleNet. That's because they are a payments network. So Ripple's claim is that they are an independent software company enabling the financial future, right? Which is to help cross-border payments and just help companies essentially move money. And they've been successful at that. In fact, they have hundreds of banks that are using RippleNet to move money. And one of them is actually MoneyGram, who is still operating on the Ripple network. They don't seem to be as concerned as some of the other people who are reacting to this claim. So that's what their business is about. Okay, it's not just the XRP. Of course, the SEC claim is that they're basically using the XRP as part of their business as a common enterprise. So what happened after word of this lawsuit got out? Well, Ripple plummeted about 30% in just a number of hours. This figure is probably changed. I think that it's actually gone up to about 30 cents. So each time I try and do this video, I see that the price is always fluctuating. But, make no mistake, Ripple has lost, nearly 50% at some point in the last day or two because of this action from the SEC. I want to talk about another issue I find interesting. So this is kind of a famous SEC directive that the whole industry took note of, that they issued in 2017. And they basically put it out there that, for example, DAO tokens, the famous fiasco, are digital assets but securities. And I think part of that is because participants were rewarded with Ether for participating. So that's part of the distinction that they made. And they just let you know that tokens might be considered a security, especially the ICOs. Now, what's a little bit different, I think, about Ripple as well, Ripple is not an ICO in the sense that they're trying to say that essentially buying an XRP cryptocurrency is the same thing as buying like a token or interest in Ripple, the company. And this is another key, I think, point to resolving this case. So I don't know if that's the case here, if that's actually true. And I'm going to give my own thoughts as we go through this. And maybe you guys can provide your own thoughts as well as you go through this video with me. So I'm going to call it the good list from the SEC. The SEC says Ethereum and Bitcoin are not securities. So I find that interesting, and I would agree. But it's interesting. I'm going to say it's interesting, especially I would also throw Litecoin in here. So I want to talk about Vitalik Buterin, the founder of Ethereum, and Charlie Lee, the founder of Litecoin, both of who enriched themselves by selling their coins. You could argue they also promoted them as well. But the SEC put them on the good list. I think part of that as well is that one thing in common, we'll talk about that at the end though, what these coins have in common is that they are mineable. Yes, they are sold and they can be bought, but to actually create them, they must be mined. And that takes real work and real money, and that's something that you, the person, has to do, and you're in control of how much you mine, in theory. I mean, not everyone has the equipment and money to mine as much as the rest of them. And as well, Hinman, the SEC Division of Corporate Finance, they said that part of their key factor in determining whether a security is being sold is how it gets sold and also expectations of the purchaser. I think that's really hard to define. How do you define, in this case, what is the average purchaser? Obviously, they're trying to define the average purchaser as as market makers, which admittedly Ripple has alluded to. But I don't consider myself a market maker. I do believe in the XRP. I have bought it. I don't consider myself just a pure investor. I do see XRP as something, yes, that can appreciate, but also has a use. And I think that's going to be also a key point in defending that case. So the Howey Test that I mentioned earlier, it was a precedent set in 1946, the SEC versus Howey. And really quickly here, it had to do with the investment of land and farms that had citrus trees on them. And so this test came out as a result of that case. And so the 4 criteria that are going to be applied to anything that is going to be considered a security, you must pass all 4 of these criteria. So naturally, in the crypto space, everyone wants to fail this test. In other words, it's the only test that you probably want to fail in your life. So 1, there has to be investment of money. Yes, there's investment of money if you're buying XRP or any cryptocurrency. 2, expectation of profit. You could reasonably say from anyone buying cryptocurrency, I think it's fair to say, yes, there would be an expectation of profit. 3, is this profit going to be coming from the efforts of others? With XRP, yes and no. Now, the SEC, obviously they're alleging that all the value of the XRP has come from the action and activities as Ripple as a company. And the final one is that it has to be in a common enterprise. And so I've read some legal opinions that say it has to be on a horizontal level. It's really kind of beyond me to describe well enough here. I'm not a legal expert. But the common enterprise obviously would have to be Ripple as a company. And so this is where I'm a little stuck on. Really stuck. I don't believe when I bought XRP that I was ever told or had the expectation or was given any reasonable expectation that I would have any shareholder or voting rights or any impact on Ripple the company. I understood that Ripple the company made the XRP cryptocurrency, but I didn't see that any connection aside from that. And I don't see how they can prove that us as an investor possibly who bought XRP would have some investment in that common enterprise. I don't see that connection, and I personally think it's remote. But nevertheless, obviously, we'll see here that the SEC does its best to establish this. So I took some of the paragraphs out of the actual lawsuit here, and just a few things I found interesting. Obviously, there's about 71 pages if you want to read through it. But they said that the defendants repeatedly said publicly that they would, spend a lot of effort, would take a lot of effort to create a market or use for XRP to make banks and financial companies want to use it. That's true, but this is the tricky thing here. So myself, as someone who bought XRP, I could say the very same thing, that it's going to take a lot of work to get people to use the XRP. I wasn't of that opinion, though. I think the use case for XRP already is there. Where it gets tricky, though, is the claim here is they're saying Ripple was trying to develop the XRP market as a company, as a common enterprise here. This is what it gets at. So I don't exactly say, I don't know I really agree with this claim here, but that's what they're saying. And also the thing is, when they say Ripple, right, are they talking in terms of their XRP only as a cryptocurrency, or are they talking as Ripple as a company? And I think that, the judge in this case is going to have a hard time, but they'll have to draw some kind of line of distinction. In what capacity are they even talking about? Are they talking about the possible success of XRP? Or is it something independent, right? Because Ripple is their business, it's their company, and Ripple is trying to get companies on board on RippleNet, right? Obviously, the XRP is involved, but just because XRP might be involved as part of the settlement in that transaction doesn't mean necessarily, I think, that that Ripple is a common enterprise in this case. Okay, and so we can see here they do try and really, really hard to establish that, right? B, purchasers of XRP invested into a common enterprise. I was not aware of this. Like I said, I was never told I have any kind of share interest in Ripple as a company. But the SEC is claiming that by purchasing XRP in what they say is the offering, that is an offering in a common enterprise or akin to, I guess, buying shares in Ripple. Now, I don't agree with this. I know there's many paragraphs here where they give examples of what they say are proof of this. Now, they also talk in paragraph 267 how funds are pooled or raised in the offering and then used to fund their operations. Well, that's an interesting claim. I mean, anyone could do this, for example, and it's odd to me because they don't need to do that per se, right? If they're saying that Ripple is a company that's really one and the same as XRP on a common enterprise, why be a company? Why would they have not just been like a Ethereum team or a Litecoin team or Monero team or any other group that has created just kind of a currency and not a company that is working with it? So if they're going to make the allegation, it's odd to me. If I were the judge, I'd probably question, if you're saying they did this, why did they do that? They didn't need to do that. If their whole thing was about XRP and making money off it, I think they had the means already to make the XRP succeed just by promoting it and releasing it in the same manner as any other cryptocurrency. So I think it's going to be a hard one. They're saying that they sold those funds. It was meant entirely to fund the business. Is that material in proving that they were a common enterprise? I don't know. I'm not a legal expert. But it could be a point for the SEC. But at the same time, many people who are, into crypto and founders of crypto have sold for big profits. Doesn't mean that they are a common enterprise as a result of that. So what's Ripple's defense here? Well, Ripple has claimed that the SEC allowed the XRP to function as a currency now for over 8 years. And they're obviously going to be challenging it, right? And they also said that, just the fact that someone has an XRP cryptocurrency coin does not create any relationship or rights in Ripple. I would agree with that. And so for them to be a security, I think that has to be true. And I don't see how it can be proven to be true. Even if some investors believe that, I've never seen any claims at all from Ripple that made me think this is the case. In fact, what they're saying here is what I've always understood to be the case. I understood that Ripple is using XRP, in some RippleNet transactions, and I think it does give people confidence. But in of itself, I've never felt that owning XRP creates any relationship or interest in the Ripple as a company. And I thought this was very interesting. In paragraph 336, they talk about the current CEO, Garlinghouse, saying that as of the date that he said this, that they haven't been able to use XRP, to really affect the cross-border transactions. So he said that Ripple did expect this, for at least one bank to be using XRP in their flows or to use the XRapid product. I don't know exactly about then, but they have many banks on board which are using RippleNet. I think that alone should prove, hopefully, that Ripple is, is in that business of being a software company, providing the payment platform where XRP ends up being used as a mean to settle some transactions. But the SEC is almost using it against them, saying that their failure in doing this means that. I'll go back again to the point I make. They really want to do this. They're saying that that Ripple is just here to piggyback and make all their money off XRP as a common enterprise and not actually as the company they claim and products they claim to be offering, then why do this, right? If they wanted to make money, I don't see why they wouldn't have just made XRP as a typical cryptocurrency. So to me, it kind of defies a bit of logic there. And as well, paragraph 349. So they're saying that when Ripple was sold XRP as a cryptocurrency, that it wasn't sold as as how it could be used. I don't think that's true. There has been different marketing, obviously, that has gone on out there. I was not looking at it just as that. Actually, the one thing I like about XRP is that it works very well. I think it's actually one of the best tools to send micropayments. Forget about the banks if you're not a bank. I think XRP works very well, efficiently and affordably to actually send money to and from. I think it would work well for payments, whereas Bitcoin and other mined coins, I think they're just too slow to be used as everyday payments to replace kind of the traditional debiting system that we have. Whereas XRP is super cheap to use and very fast, and that's why it appealed to me. I bought it, and I believed it would be successful as that, and because banks were also going to be using XRP to do some of the settlements in Ripple. So yeah, I guess that's where the SEC is getting it there. To me, though, for them to make that claim that Ripple exists only to profit off XRP, I don't know if that's true. Even at the fact that they sold XRP is true, they made money. Anyone who has released a coin that's been worth anything has sold it and made money. Yet their currencies aren't being defined as being a security. And another weird question I have, you can look through this, you see reference after reference to two mysterious people. One is called Cryptographer 1 and Ripple Agent 1. So who are they? Why don't we have any kind of name? They're just pseudonyms. It's very odd. And so it looks like they've relied a lot on their kind of testimony or statements and claims to build this case. And if we're going to do that, the interesting thing is this, and I'm not sure they're really informant. They've been informants for a long time, and they left the company, or they're disgruntled workers. But they actually use statements, that were made by these different supposed people from Ripple. And the question to me comes down to, in what capacity were they speaking? Were they speaking on a personal level? Were they speaking in terms of XRP as a cryptocurrency? Were they speaking on behalf of Ripple? And were they authorized to even do that? So that's what it comes down to me. I don't know if the judge will look at it the same way, but I do have some questions about who these people are, and how can we rely on their statements to qualify the XRP as a security. So I also mentioned this about mining. So many commentators have been speculating that the SEC, they've used part of the fact that if a coin is mineable through your own work, right, and you're making money from that, and the value is going up because people are mining it, then obviously that could be a reason why. You can't claim if people are mining it on their own that this comes from the efforts of others. Although if they want to be remote, I guess they could, because realistically today, when it comes to mining, you don't really mine anything on your own. You actually pool your resources, which kind of gets really close to meeting some aspects of the Howey Test. You're pooling your resources to mine, and everyone kind of profits equally based on the amount of work they put in or amount of energy and computing power that they provide. But anyway, I digress on that issue. It's a mystery to me, but I do think that maybe part of it is that for some reason they've defined internally that if someone is mining this coin, it's not going to be considered a security, whereas anything else might be kind of open season. So the conclusion here, right, when looking at the case here, I think the SEC is going to have to establish in a court of law that what they're saying obviously is correct, in terms of how the XRP was sold, and the XRP is a security and not a cryptocurrency. And as well, Ripple is going to have to defend that XRP is a true cryptocurrency in of itself, has a true use, and is completely separate from Ripple as a company, and make that distinction and help the judge to understand that there's a clear distinction between Ripple as a company and the XRP and how it's used and how it functions on its own. So for me, what it comes down to is this. Do I think Ripple's dead in the water at this point? I really don't. They have enough money to defend themselves. Do I think the SEC is entirely right? I do think if you look through the claims here, they do make some valid point. I think Ripple also makes some valid points. So what I actually conclude at the end, if you look at this, it's a little bit of a gray area. I don't know how this resolves. Obviously, it's a very important case. Do I think that the game has changed since this lawsuit has been filed? I really don't. I don't know if the SEC has as strong of a case as they say. And, they have to prove all 4 points of the Howey test and have the judge accept that for, to be successful. And even if they do, I'm going to assume Ripple's counsel is going to defend that vigorously and say that you couldn't even apply the Howey test. This is not, this is a new situation. This situation is not valid to apply the Howey test to. And so I'm sure they have all kinds of legal strategies to try and mitigate any of the claims the SEC is making. And the other question is, too, I wonder, do they go to court or do they have some kind of out-of-court settlement? Would the SEC be willing to do that? Well, I'm not sure. No one can really be sure, guys, what the future is. I don't think XRP is going anywhere. Even if Ripple as a company goes down, the XRP cryptocurrency is going to continue to function. And then the cool thing is that I think what might happen, if Ripple is out of the picture, even if they don't succeed here, yes, XRP will take a temporary plummet. The technology that they're using, the open coin technology they use, and XRP on its own, I still stand by it. I think it functions very well. And I think XRP would and should be first in line to try and replace our current financial system, at least the day-to-day financial system. I don't think XRP is going to be the first store of value, but for making microtransactions and kind of that instant kind of payment from person to person, I don't think anything really beats XRP, considering its position in the marketplace and adoption that we've seen, right? And banks also seem to like it quite as well. So, guys, I'm quite excited about the future of Ripple. I know it's weird. Ripple's a cryptocurrency, and as a company, obviously some things are up in the air. Do I think there's reason to panic and sell off? I'll tell you, I haven't sold any of my Ripples yet. I mean, any of my XRPs. I'm keeping them. I'm going to wait and see what happens. But I do believe in it. And I do think even if Ripple as a company fades away, that a new community will step forward and continue to develop and promote and work on XRP in a similar way. Maybe it's going to be a fresh start in the worst case scenario where XRP might be handled that way. But obviously it could be a totally different story if it's deemed to be a security. I just don't see how they would deem XRP itself, which functions on its own even if Ripple's dead, to be security. Even if they actually say that Ripple as a company sold a security or sold Ripple XRP like a security. XRP, how do you say that the currency that we're using on a daily basis is only for speculation, it has no use, when we know very well that it does? So guys, these are just my quick thoughts. Let me know yours if you've seen anything else that you find interesting. I'm going to give a link to the claim here from the SEC. I'd like to wish everyone a happy holiday, a safe holiday, and once again, this has been Arif Suez here. Take care, guys, and I'll see you next time.